on nationality, citizenship, and immigration policy. But before we do so, I have a couple of quick announcements. Following this session, there's going to be boxed lunches available in the foyer. You could take them, and because of the weather, normally you can eat outside, but we're going to allow you to eat in the classrooms. So you can take your lunch to classroom 109, 110, or 140, okay? And there'll be people there to direct you as well. And also, if you're interested in participating in a breakout session, be sure to sign up at the registration desk before lunch ends. Thank you.
Also, the lunch is going to be quick because we have Jock Sharfin, who's the acting USCIS head, who's speaking, I think, at 1:15. Is that right? So it's only 45 minutes for lunch, assuming that we don't go over here, which we hope not to. Our topic is nationality, citizenship, and immigration policy. We have excluding myself, an all-star cast of panelists to my right. I'm grateful always for Alex Aleinikoff's presence here. He's always been very generous with us in hosting this event and with his time and expertise. I remember, 5 years ago, how bemused Alex was that we called our first annual Law and Policy Conference the first annual Law and Policy Conference. It was kind of the joke of the session all day, and now we're at our 5th annual Law and Policy Conference, and we owe Georgetown a round of thanks for hosting us all of these years, and Alex for supporting it. I also wanted to thank Margaret Stock, who's actually on her way to Congress later today to testify on some of the, well, actually I'm going to let her speak about that a little bit because I think it's a very compelling topic that she's going to testify on. Margaret, if you don't know her, is the U.S. military's expert on immigration law and immigration issues, and she's everybody's expert on national security issues and citizenship issues. So we're thrilled to have her. The way we're going to divide this topic is I'm going to actually not be so political, and I'm going to talk about 3 views of nationality that I think underlie the immigration debate and kind of tease out the implications of those views. Alex is then going to discuss the relationship between immigration and citizenship, talking about some recent scholarship. And Margaret, who thought that when she heard our topics, thought that Alex and I were sounding very highfalutin and very philosophical in our topics, is actually going to speak about the issue of birthright citizenship, which Senator Van de Putte spoke about a bit earlier. We're going to speak for 10 to 15 minutes each and leave time, hopefully, for comments, questions, discussion at the end, so we hope that you'll have some. To me, more and more the immigration debate and it has been for, at least over the last year. It seems to me it's about values and competing visions for the country. We do need viable policy proposals. There's no doubt about that. But people do approach these issues from the level of values and vision, or what our advocate press friends call their own narratives. Conversely, I think it's very difficult to craft policy prescriptions without some clarity on what kind of nation and what kind of communities we're trying to create. It seems to me that you have 3 sometimes overlapping views of nationality playing out in the immigration debate. So I thought I'd describe them and again try to tease them out. The first is, and let me turn to Pat Buchanan to enunciate the first. This is how he describes the United States. He writes, "Every true nation is the creation of a unique people, separate from all others. Indeed, if America is an ideological nation grounded no deeper than in the sandy soil of abstract ideas, she will not survive the storms of this century." What he argues is that a distinct people actually existed and it preceded the creation of the Constitution, that these are the people that over the years have sustained the country, and that our immigration policy should be perpetuating these people and certainly shouldn't be diluting them. So it's the composition of the people, then, under this view, that defines the nation and that brings it cohesion, not their ideals. How are they composed? Well, that's where you run into some trouble, because they have common ethnicity, religion, history, culture, and culture not just in the sense of civic culture. They share blood and soil, etc. This view has been called the new nativism, or ethnocultural nationalism. And actually, it's a lot like the old nativism, as it turns out. you ask yourself what religion characterizes the American people. And not too long ago, in the scheme of things, it wasn't Jews and Catholics, of course. They wouldn't have made the cut, just as Muslims don't make the cut now. The know-nothings who actually called themselves the American Party discriminated against Catholic and Jews in the name of religious liberty, actually. What nationality or ethnicity? Well, not too long ago, it wouldn't have been Italians or Poles or Irish, for those of us who know history, just as it's not Mexicans under this view today. One prominent commentator has put it very bluntly. He said, the American nation has always had a specific ethnic core, and that's white. Proponents of this view, I think, can espouse an uncritical and fixed view of U.S. history as well. If we're defined by our common history, we need to recall that the all men who were created equal in our Declaration of Independence did not, in fact, in the founders' view, include all men, and it didn't include any women at all. If we care about shared history and ideals, we need to remember that for nearly a century, slaveholders actually argued for slavery based on a shared history and heritage. So the salient consideration for full membership under the new nativism is that you either have the inherited characteristics, like ethnicity, or you need to change characteristics, like religion, that are central to your identity, but that have nothing to do with your civic or political values. How does this view play out in the immigration debate? Well, if you want to perpetuate a unique people, it's not surprising that you would favor reduced admissions or the denial of admissions or the deportation of family members of U.S. citizens who presumably don't have those characteristics that you favor. You'd be concerned about chain migration, not so much because of the numbers, but because of who's actually being admitted. However, here's an anomaly to me anyway. If what matters to you is shared history and culture and soil, why would you oppose birthright citizenship for the children of the undocumented? Most of these children, if denied U.S. citizenship, might technically not be stateless, but a lot of them will never have another home or culture or history than ours. And yet we know that 96 members of Congress endorsed legislation to deny birthright citizenship without amending the Constitution to the children of the undocumented just last year alone. Peter Spiro has said that this would create a hereditary underclass of persons, which is repugnant to our values. This is true, but again, this vision is not primarily about values or ideals. It's about perpetuating a people. The next two views of nationality are forms of civic nationalism. That is, that both view the United States in terms of its civic values and ideals. And they see these ideals as a beacon of hope to the world. Neither of these views would automatically exclude immigrants based on inherited characteristics. The more conservative, civic nationalism focuses on assimilation into a relatively fixed U.S. identity, whether it's linguistic assimilation, civic assimilation, patriotic assimilation. It's loyalty and allegiance to our constitutional democracy and our way of life that are crucially important, which is why dual citizenship and perhaps dual allegiance troubles proponents of this view. Learning our history, speaking our language, committing to our system of government is crucially important to these folks. And this is why they favor a very rigorous naturalization process. The group, and I think we can expect this, they also are in support, or some of them anyway, in support of ideological exclusions. One recent idea which is going to come up is to exclude people who believe that the U.S. ought ultimately to adopt or to accommodate Sharia law. The group also worries that high numbers of immigrants will make assimilation difficult and will lead to the dilution of U.S. ideals. And just as importantly, they believe that one of the core ideals is the rule of law, which they tend to equate with obedience to the law and enforcement of the law. As Marianne Glendon, the Harvard professor, points out, the primacy our civic culture places on adherence to the law is not surprising in a nation otherwise as diverse as ours. It's actually one of the characteristics of our country that make it attractive to immigrants. So to this way of thinking, breaking the law can seem like a challenge to the national enterprise as a whole. Thus, people in this camp strongly distinguish between legal and illegal immigration. You can also find this vision among people who think mistakenly that the undocumented have chosen to be undocumented as a way to game the system. It's a very pervasive view, actually. In other words, to receive all of its benefits, but to assume none of its responsibilities and to adopt none of its mores. These people want to get tough on the undocumented by either deporting them or forcing them to become citizens. Okay. The third view is kind of the liberal version of civic nationalism, and that holds that the United States is united by a shared commitment to universal ideals like freedom, equality, rights, opportunity, liberty, democracy, you name it. They cite Abraham Lincoln for the statement that the U.S. is a nation devoted to a proposition. Woodrow Wilson, in a great speech in 1915 to newly naturalized citizens, put it this way: "You have taken an oath of allegiance to a great ideal, to a great body of principles, to a great hope of the human race." Part of this vision is that membership is not just about support for abstract values, but it's about a commitment to bridging the gap between those values and our practices. Proponents of this view tend to view immigrants as people who embody these values and who renew them, and as a result they favor generous immigration policies and less of a division in public life between the treatment of U.S. citizens and non-citizens. On the rule of law issue, what they'd say is, I think what Frank said this morning, they'd say that the rule of law can't be equated totally with law and order. Laws do need to be enforced, but a system that honored the rule of law would have certain attributes which our immigration system doesn't. A system that honored the rule of law would respect rights, but our system doesn't always do that. So people in this school see the need to enforce the law, but they also see the need for top-to-bottom immigration reform. And I've got to say, you find this view in surprising places, at least we did. Margaret and I produced a long report a couple of years ago about national security and immigration, where we interviewed a number of security experts. And almost to the person, they told us that respect for rights had to be seen as crucial to national security. Rights define our nation, they said, and national security has to encompass protection of them. That's the kind of country, a country devoted to ideals, that a lot of the experts, the counterterror experts and the military folks that we interviewed said that they're defending. Okay, let me close with two thoughts. First, I'm not sure that any of these views, which I think do need to be developed, have come to terms with the way in which our sense of sovereignty is changing. There's nothing novel, particularly at this point, in the observation that globalization and human rights challenge the traditional system of nation-states. Philip Bobbitt and others have extensively argued that we're entering a post-Treaty of Westphalian age, that the market state is supplanting the nation-state. And it's true, I think, that we're seeing globalization spurring migration. And it also seems to me that the uneven distribution of globalization's benefits is underlying some of the backlash against immigrants. On human rights, it's our Declaration of Independence itself that stipulates that governments are instituted to secure rights. So the protection of rights doesn't limit sovereignty under this view, but it actually underlies it. If so, then it doesn't seem to me to be such a stretch to say that in the case of many migrants, particularly forced migrants, the system of sovereign states is not serving its purpose. The notion of absolute sovereignty is also undercut by the religious or ethical sense, that the goods of the world belong to humanity, to all of us. I think that liberal nationalist theory may best come to terms with this shift, but actually I think that none of the theories fully account for it. This conference is actually devoted to the immigration challenges that are going to confront the next administration. And it seems to me, in closing, that the fundamental issue that the next administration will face related to immigration is what kind of nation we want. What do we want as a nation? And let me characterize, or let me read to you how one person characterized our nation. He said, "America has never been united by blood or birth or soil. Instead, we are bound by ideals that move us beyond our background and that lift us above our interests." What are these ideals? Well, this person said, everyone belongs, everyone deserves a chance, and no insignificant person was ever born. That was I'm actually quoting from George W. Bush's first inaugural speech. I think that actually that's a good starting point. In the new administration, things seem to have gotten mixed up along the way, but the new administration actually couldn't do better than to start in its approach to immigration with a view of our nation like that. Okay, let me ask Alex to come up.
I'll speak from here. Okay. Thanks, Don. I think that may be the only time in this political campaign when George Bush is cited favorably by either side, actually. So that's kind of a first. So I want to follow up on Don's final point of the liberal nationalist versus the post-nationalist perspective on citizenship by talking about two recent books, and we'll maintain the academic character of this panel and talk about some policy implications at the end and ways of talking about citizenship that may be useful in the next administration. We are a liberal democracy in this country, and we have a strong notion of citizenship, and yet there is a really very deep tension between the idea of a concept of citizenship and liberal democracy. On the one hand, robust membership in a state of citizenship may be necessary for effective democratic processes. You need to know who's in, who can vote, and how. And also for policies pursuing social and economic justice. Who do we care for in our society? And unifying policies on the basis of citizenship seems far preferable to other unifying markers we've used from time to time in our history, such as race, religion, or ethnicity. So citizenship has this very powerful appeal in a liberal democracy. On the other hand, the rights and entitlements that come from an accident of birth appear remarkably arbitrary under classic liberal theory. And a recent academic paper draws an analogy between birthright citizenship, the core of our citizenship policy, and inherited property rights, that is, seeing the distribution of citizenship as supporting massive global inequalities. So as we talk about, I'm sure throughout this conference, about the importance of maintaining birthright citizenship, it's also worth thinking about the ways in which birthright citizenship, the accident of birth, in fact, is the main engine responsible for basically worldwide apartheid. Where you are born determines your life chances to a huge extent. We got to play with that tension a little bit. Two recent books demonstrate the tensions here, and I'll talk about a book by Hiroshi Motomura called Americans in Waiting and a book by Peter Spiro called Beyond Citizenship, both published in the last couple of years. Motomura's book argues that we should return to an earlier tradition of seeing immigrants as citizens in training. I call this the straight line view of immigration. Immigrants come in, they stay for a few probationary years, they prove themselves worthy of membership, they're naturalized, and frequently naturalization is sort of seen as the end of the story. We all know that it's not. But this is the view of seeing immigrants as would-be citizens in training. The essence of the proposal, writes Motomura, is to treat a new lawful immigrant more generously, but also to use that extra generosity to help him take full advantage of the opportunity to integrate into America. So he supports granting immigrants benefits upon settlement in the nation with the aim of fostering a more robust citizenship once they naturalize. If you want people to be full citizens at the time of naturalization, help them integrate before they naturalize. A further implication of his work is that immigrants should be denied benefits if they choose not to naturalize when they're eligible to do so. This approach contrasts with other approaches that we're used to. I would call a human rights approach that says basically anyone in the territory is afforded certain human rights. It shouldn't turn on status of being an LPR or a citizen in waiting or in training, or a view that views naturalization as the point at which people acquire rights, sort of being an on-off switch of being a full member, and membership, as we know, has its privileges. So Motomura is charting a third way here to remind us of citizenship as the end of this function of immigration, as a way to smooth the immigrants' assimilation into full membership. Now, Peter Spiro's book, Beyond Citizenship, describes national citizenship in a way that makes Motomura's project seem already out of date. He argues that the idea of citizenship as deeply meaningful, exclusive, and tied to a particular nation-state is, in fact, fading fast. The traditional U.S. model has been based on what he calls the territorial premise, but that premise is under serious pressure from the rise in global migration, dual nationality, and the thickening of diasporic and transnational communities. He writes that, quote, globalization makes possible the intergenerational maintenance of non-territorial ties, and, quote, that we are likely to see the diffusion of identity to various non-state and, in many cases, non-territorial forms of association. Spiro's thesis is that it's a narrative of irreversible decline of American national identity, and it's reflected in our citizenship regime. He says this: territorial presence and strong norms against dual citizenship played crucial functions in maintaining a coherent citizenry coinciding with community on the ground. Those backstops are no longer available to shore up community, now breached by the global diffusion of culture and democratic governance. And on this view, national citizenship is deprivileged. It's just one form of association among many that we may have. Not only does citizenship offer less, but non-national associations appear to offer more, much of what citizenship has traditionally promised. Now, Moderator is aware of the Spiro critique, and he says there are certainly other modes of belonging, including transnational models that reflect a sense of belonging to more than one nation. But then he argues against the Spiro view as follows. He says, the apparent inclusiveness of these other approaches, like Spiro's, to belonging, can mask other modes of exclusion. If national citizenship matters less, ties of religion, race, and class, and other groupings that are less cosmopolitan or democratic than national citizenship will matter even more than they do already. The result may be a world without national walls, but a world of, quote, 1,000 petty fortresses. There he's quoting a famous article by Michael Walzer. So Moderator pins his hope on preserving or resurrecting a national citizenship in the United States, quote, as a viable context for a sense of belonging and for participation in civic, political, social, and economic life that is inclusive and respectful of all individuals. You get the two models, one that sees immigrants becoming citizens into a full national whole that resurrects a caring community, the other saying it's already the game, the cat's out of the bag, the barn door's closed, the horse is out, whatever the right metaphor is, we've lost the game on citizenship. We're into new kinds of transnational models of belonging that are fundamentally challenging this idea of a sweet and coherent whole. So let me offer just a critique of both views and a couple of policy suggestions at the end here. Moderator's project wants it all to come out right, a robust nation of robust citizens caring for each other and respecting each other's diversity. But Spiro's critique, to my mind, is trenchant. Significant levels of migration, enhanced travel, and communication are as likely to engender diverse transnational communities as to produce diversity-respecting citizens. Furthermore, Moderator asserts that his narrative is comfortable with openness towards dual nationality because not requiring immigrants to renounce other citizenships is likely to increase naturalization rates, and because acceptance of dual nationality makes clear that naturalization does not require identity transformation. This latter virtue is Spiro's vice, and it's not easy for me to see why Moderator is not trying to have it both ways, to make citizenship more special, but not to load too much meaning into it. Moderator has a nifty way of giving rights to immigrants as citizens in training, but it would seem that advancing notions of human rights, which are irrespective of notions of alienage and nationality, would do a more persuasive job for endowing all people in the country with rights, and would also provide protection for undocumented migrants that are left out of Moderator's account, since he's talking about people lawfully on the naturalization track. So Moderator's argument works on behalf of permanent resident aliens, and assuming that the proposal gains momentum, it seems to me, I wonder why the answer, if one is worried about giving too many rights, wouldn't simply be to push more people onto the temporary track, right? If I were a legislature knowing that under Moderator's theory, anyone who comes in immediately gets all rights, well, let's have some more temporary workers then as a way to cut back on benefits and rights packages. Spiro, as noted, sees the coming or already present world of migration as quite different from the traditional straight-line view of immigration, of immigrant to resident to citizen that underlies Moderator's book. 20th century models of the nation-state and citizenship, according to Spiro, will be increasingly compromised. Our current and future world is one of overlapping legal authorities and a world of diasporas, migratory circuits, overlapping communities, and dual nationality. This is the way immigration is experienced on the ground in our communities, isn't it, with these kinds of mixed families and travel back and forth. But I think there are problems as well with Spiro's account. First, he overstates, I think, the weakening of the U.S. citizenship and national identity. The most recent data, which was released, in fairness to him, after his book, shows, once again, a sharp rise in naturalization rates. And there's no strong evidence that dual nationality, birth abroad, or citizenship for the children of temporary residents, these are all things he points to as weakening the citizenship regime has in fact weakened notions of U.S. citizenship, or that the number of persons in these various categories constitutes a substantial portion of the U.S. population. Furthermore, the transnational trends that Spiro identifies may be working on behalf of a small and privileged slice of humankind. So Catherine Deneuve has written an Catherine Deneuve, great. Catherine...
Okay.
She's got a new movie coming out. It's being released in Cannes. Maybe that's what I'm thinking about here. Anyway, Catherine D'Auvergne argues that, this is her argument, for the privileged subjects of globalization, citizenship is becoming more flexible, more states more tolerant of dual citizenship. Formal inequalities are being worked out of citizenship laws, and citizenship requirements are more perfunctory for the privileged few. However, for those, quote, already disadvantaged and excluded, citizenship laws becoming increasingly exclusionary. For illegal migrants, the story is one of citizenship with a vengeance. What a phrase, citizenship with a vengeance. It's the name of the article she wrote. And finally, as to Spiro's theoretical claim, I think it's problematic. He argues that a weakening of national citizenship will ultimately bring it down to the level of other kinds of group associations in civil society, like ethnic groups people belong to, or religions, or other kinds of occupational associational groups. But while perhaps it's true the nation-state form is evolving or even declining, what is ascendant is not a set of other non-political associations. We're not witnessing the rise of world anarchy or the end of history. Rather, we're likely to see the development and strengthening of other political institutions, regional, transnational, some even global. These political organizations, institutions, associations, exercising what will be perceived as legitimate legal and coercive authority, will need to have theories of membership. And you can call this membership citizenship prime or citizenship star, but nonetheless, we will be evolving into these kinds of regional and supranational organizations, and it may simply be that our notions of citizenship will move to those associations rather than simply, as Spiro argues, declining altogether. So what follows from this? Or, say it another way, can academic scholarship be useful to policymakers? I think a conference like this the purpose of this conference is to try to bring these worlds together and see what we can learn from each other. So let me see what conclusions I can draw from both works. And I think one can find interesting policy implications in both. First, for Moderator, I think he is right to see immigrants as citizens in training, even if not all are, if some maintain deep transnational ties that undercut their close affiliation with the United States. Many, perhaps most immigrants are on the citizenship track and feel that, have that sense of affiliation. If they don't, certainly their kids do. Moreover, I think as a rhetorical matter, it's a very strong move in the current debate. Right? For people who, it may well be right as a legal matter and a moral matter to say all persons in the United States have human rights no matter where they're born. There's no such thing as an illegal person. Alien, the word alien has taken on a bad sense to it. It's an awkward word, as we all know. Nonetheless, that does not seem to be persuasive political rhetoric. And it seems to me that the argument that we should view immigrants as citizens in training is actually a much happier way to go on this. Citizenship is good. Linking immigration to citizenship may well be a strong rhetorical move. Secondly, his work focuses us on integration. And again, the time has come, and we've said this, I think, every year. It's been said by someone or several people in this conference that we have an immigration policy, but not an immigrant policy, and that we need to focus much more on integration. That's something that should unite people across political lines of helping people become citizens. It fits entirely into Moderator's project. Thirdly, it's an argument for restoring more fully benefits to lawful permanent residents. And fourthly, I would argue, and here I know I'm well beyond the current political climate, I think it's time to start talking about voting rights for permanent resident aliens in this country. It'll take some time, start at local levels, push it beyond Tacoma Park, our wonderful Tacoma Park, which is always leading us 10 or 20 years ahead. I think it really is time to push seriously for voting rights for immigrants. It'll jar people like crazy to start. It'll have a backlash, but in the end, it's right. There should be be voting rights, at least at the local level, for school boards and other kinds of activities for people who pay the taxes and do the hard work in our country. All that is consistent with Moderator's thinking. His problem, I think, is his strategy does not give us clear purchase on the issue of regularization, or on birthright citizenship for that matter. You can make the arguments, but it's a little strained, and there have to be other kinds of arguments other than immigrants as citizens in training, I think, to make strong regularization arguments. Maybe that's where the human rights side comes in to work in tandem with his view. Spiro, I think, however, is right to have us focus on the changing shape of political association and allegiance. We probably, in the current political climate, need to talk seriously about the nation state and the people and citizenship and the role that plays in a world of increasing danger as it's perceived. But I think it may well be that the next administration, which will be more open to the world, will see a world less of nation states building bunkers around themselves and more as part of alliances for progress. I guess that's an old phrase, but alliances with other organizations for efforts at solving world problems together. That is where we are moving clearly, whether we have the political rhetoric or the political will to say that now. And Spiro is pushing us to think about those forms of political association and allegiance. It certainly also is a way to be open to notions of dual nationality. So I guess my bottom line here is that Moderator's work may well be translatable into current political rhetoric that would be useful in the short term, but keep an eye on Peter Spiro's writing. I think he's got the right story for the future. We just haven't quite developed the vocabulary to get us there. Thank you.
Well, I'm going to turn things a little in the direction of practical impact rather than deep philosophy by following up Alex's remarks with the discussion of the birthright citizenship issue that was mentioned earlier today by the senator. The term anchor baby is going to come up a little bit in my talk. I don't think that appears in either Hiroshi's book or Peter's work. So you'll have to forgive me for that. But essentially, I want to tackle on a practical level an area that you hear a lot about in the news. Serious people are talking about new interpretations of the 14th Amendment. Of course, the 14th Amendment having a clause that says anybody born within the United States is a citizen as long as they're subject to the jurisdiction of the United States. They're a citizen. And there's increasing talk that we should either repeal the 14th Amendment altogether or we should reinterpret that language subject to the jurisdiction to exclude people who are not already citizens or lawful permanent residents of the United States so that their children would not become citizens of the United States at birth or birthright citizens. So that's a topic that I'm going to tackle, but before I get into that, I need to tell you all that everything I say today is my personal opinion only, and it's not necessarily the opinion of the United States Military Academy, the Department of the Army, the Department of Defense, or any other government agency. So what I want to talk about, rather than deep philosophy, is what would happen in the United States of America if we did in fact decide to change the rules regarding birthright citizenship. And today this is seen as a way to stem the flow of illegal immigration. You'll hear people talk about repealing birthright citizenship as a deterrent. It's frequently a topic of discussion on op-ed pages. New York Times has even published a few letters to the editor from educated people who say it's crazy what we're doing now, letting all these people run across the border and have babies and letting those babies be American citizens at birth. We need to change this rule. So to start, I'm going to tell a story. Alex told me that stories are common on Capitol Hill, so I'm going to tell one. Don also mentioned I got to testify in front of Congress today, and I'm going to tell lots of stories there, but not the same one, so you're lucky. The story I'm going to tell to start off, to illustrate the dilemma that we're in with this issue of birthright citizenship, is about a guy, I'm going to call him Juan Gomez. That's not his name, but I'm going to call him that. He was born in Mexico. That's true. The real guy was born in Mexico. And he came to see me when I was practicing immigration law in private practice. He wanted to have a consultation with me because he heard that I could solve all of his immigration problems. He said he'd seen 4 or 5 immigration lawyers over the years, that he was an illegal immigrant, his own words, illegal immigrant, and none of these lawyers had been able to help him. He was desperate to get legal in the United States, absolutely desperate, and he told me he'd been living illegally in the United States of America for more than 22 years with a fake name and a fake Social Security number. He also said that he had children who were born in the United States. Now, these are the famed anchor babies, and the theory you hear out there in the world on Lou Dobbs Tonight and other media outlets is that anchor babies are supposed to make you legal. So if you have children in the United States, it's supposed to be an automatic ticket to get legal in America. But this individual had a problem because he couldn't get legal through his children. First of all, they weren't 21, and you can't sponsor your parents to immigrate, with a few exceptions related to the military. You can't sponsor your parents to immigrate until you're 21. You have to be a U.S. citizen, 21 years old. And because of 1996 changes to the immigration laws, he couldn't get legal anyway, even through his children when they turned 21. So the anchor baby theory was not going to work for him. And he had heard on the street, he told me, that there was an amnesty going on for illegal immigrants, a street rumor. So he came in to talk to me to find out, how does he get legal? And he was sitting there, and I had the great, but unfortunately not rare, pleasure as an experienced immigration lawyer of going through his documents for an hour and talking to him and telling him that there was good news and bad news. The bad news was there was no amnesty going on. The good news was he was an American citizen, and he'd been an American citizen since the day he was born. And all he needed to do to, quote, get legal was fill out a passport application with the State Department, and he would get a U.S. passport. So he ran off to the passport office immediately, actually the post office immediately, with all his documents and filled out a passport application. And sure enough, 6 weeks later in the mail came his American citizen passport. Of course, at that point, he had to go deal with Social Security and the fake name and all that. But those were the least of his problems. Well, so why am I telling you this story? Well, I think it illustrates a few things that are relevant to any policy debate about birthright citizenship, and for that matter, membership in national communities and what that means. First point, as should be obvious from this anecdote, is that U.S. citizenship law, U.S. immigration law, is extraordinarily complicated. And the only thing that's easy in immigration law these days is the concept of birthright citizenship. Easy in the sense that if you have a valid American birth certificate, with a few exceptions, diplomats and invading armies and Indian tribes, you are a birthright citizen, and that's all you got to have is that birth certificate, and you've got that proof, as long as it's valid. But because the law is so tremendously complicated outside of birthright citizenship, there are thousands and thousands of Americans who don't know that they're Americans, or if they know that they're Americans, they have trouble proving that they're Americans. And a recent survey by the Brennan Center at NYU found that more than 13 million American adults cannot easily produce evidence of their citizenship. And those are people born in the United States who can't even produce it. As part of this discussion, I should point out that in addition to birthright citizenship, citizenship derived from just being born within the geographic boundaries of the United States also confers citizenship by blood, jus sanguinis, the lawyers will call that. Famous citizen by blood is Senator John McCain, who is not a birthright citizen. He was not born within the geographic boundaries of the United States. He was born in the Panama Canal Zone, at the time an unincorporated territory of the United States, so he was not born, he's not a birthright citizen. He's a citizen by blood. And then we also have citizens by naturalization, the folks who go through the lengthy process of becoming citizens by applying for it. The rules for citizenship by blood are extremely complicated. And Mr. Gomez, the individual I was talking about, turned out to be a U.S. citizen by blood. And that's why he spent years not knowing he was a citizen, because the rules there are extraordinarily complicated. And it took me, an experienced immigration lawyer, quite a long time to figure out, looking at all his paperwork and consulting statute books and figuring out what year his parents were born and what year he was born and so on, that he was a citizen. Over more than 200 years of American history, Congress has been tinkering with the citizenship by blood statutes, creating such a complex system that figuring out whether somebody who's not born in the United States is an American citizen is kind of like trying to figure out whether a patent's valid or not. It's difficult. And if we get rid of birthright citizenship, we're going to be faced with the prospect that the vast majority of Americans are going to face this daunting legal regime and have to have their citizenship adjudicated. We'll be replacing a very simple rule with one that is tremendously complex. Under the present rule, most Americans have it much easier than Juan Gomez had. All they have to do is produce their valid birth certificate and their proof that they're Americans. Were they not so presumed? And there's hundreds of Americans born overseas, hundreds of thousands actually born overseas all the time, who don't have the benefit of such a presumption. If you take away birthright citizenship, you're going to force everybody in America to go through that complex and individualized assessment of whether they're American citizens by blood or get them to naturalize. If you're familiar with the folks born overseas, you'll know that we have lots of Americans born overseas every year. I mentioned John McCain, but the U.S. military is replete with people who were U.S. citizens, not by birth in the United States, but through blood, because their parents were overseas on a military base when they were born. And these folks include not just military members, but the children of missionaries, the children of oil company employees, children of all kinds of global American companies, the children of Brad Pitt and Angelina Jolie. Okay. The State Department and the Department of Homeland Security charge a lot of money to figure out whether you're a citizen if you weren't born here. Currently, Homeland Security is charging $460. And depending on the facts, this adjudication can take quite a long time. Right now, Homeland Security is taking more than a year to process the paperwork for somebody who says that they are a U.S. citizen by blood, but not by birth in the United States. And you can be required to produce numerous documents. I should also tell you that the government makes mistakes all the time when they do these adjudications. I've learned this because I've been dealing with a lot of military folks, and it's not uncommon in the military to have a child who's born, say, in Germany, apply for Homeland Security recognition through an N-600 that the child isn't actually an American citizen, and have Homeland Security say your kid is not an American citizen and the State Department made a mistake when they issued your child a U.S. passport. You need to turn that passport in and get your kid a visitor visa to come to America. And then when your kid turns 18, your child can naturalize. Now that will sound pretty wacky to immigration lawyers in the audience, but Homeland Security actually has said that to people. I have it on tape. Okay, I can prove this. So the government makes mistakes. They screw up. They tell people they're not citizens when they are. They tell other people they are citizens when they're not because of this complex regime. And as a result of this, there's dirty little secret of immigration law, which is in the current environment where we're having increased roundups of so-called unauthorized or illegal immigrants. We're also having increased roundups of U.S. citizens. This used to be totally secret until the McClatchy papers a few months ago came out with an actual report where they counted a whole bunch of American citizens who'd been arrested by immigration, which had attempted to deport them. And there are lawsuits going on right now filed by many of those American citizens who've been rounded up and thrown into removal or deportation proceedings. So let's think from a policy perspective what happens if we eliminate birthright citizenship in America, because we think this is a good way to solve problems. Well, we don't have a national registry of American citizens. The closest thing we have is, the passport office's files, but that doesn't cover everybody. So we'd have to create some kind of national registry, and we'd have to keep track of everybody born in America. Everybody would have to have his or her citizenship adjudicated. Somebody expert would have to do that adjudication. I know there are lots of law students in the audience who would like to have jobs, so maybe you're going to push for this because you'll have a permanent job at the local hospital figuring out who's a citizen and who's not. I'm all in favor of full employment for immigration lawyers, but that's not really a problem today. The problem today in America is that we've created such a complex fabric of immigration laws that there's a huge shortage of good immigration lawyers. This is a field that the Department of Homeland Security spokesperson has aptly called a mystery and a mastery of obfuscation. They were talking about immigration law. That's Homeland Security called the law that. They're the folks who enforce it. Now, as a practical matter, few people in this audience are likely to be affected if we did change the law. Why is that? Well, I suspect people attending a conference at Georgetown Law School are members of the social elite, for the most part. And so most of the folks who are in the social elite will be able to hire a good lawyer, find a good lawyer, get their citizenship adjudicated. The burden of proving citizenship is most likely going to fall on the less favored elements in society. And in fact, one of the aspects of the dirty little secret I mentioned earlier about Homeland Security picking up U.S. citizens is normally those are not highly educated people that Homeland Security attempts to deport U.S. citizens who are getting deported. It's usually the less favored in our society, poor, the minorities, people who don't, quote, look like Americans, so we don't believe you when you say that you were born in Chicago, and we deport you to Mexico because we don't believe you when you say you were born in Chicago. So the first big policy argument I always raise when people say, well, let's get rid of birthright citizenship, that'll solve our problems, is this. We have a long-standing rule. It's a simple rule. It's easy to apply. It's easy to understand. It's easy to administer. It's a constitutional rule. It's been in effect de facto since the dawn of the Republic and through constitutional law since the Civil War. And those who would overturn or change this law really have the burden of proving why this rule should be changed as a matter of policy, not just a matter of law. I mean, it sounds really great. You know, we deter people from illegally immigrating to America by changing the rule. But some cost-benefit analysis needs to be made on what would be the implications if we got rid of this rule. And in the area of birthright citizenship, it's pretty clear that the benefits of changing the law are much less than the costs of changing the law. And nobody ever makes the argument on cost-benefit grounds about why you should change the law. People cite vague policy reasons. You know, they say, well, eliminate tourism, birthright tourism, an industry of women coming to the U.S. to have babies. And they never talk about the benefits that the U.S. has gained from having such a simple rule of birthright citizenship. Yet there's ample evidence that the U.S. has tremendous gains from this rule. There are hundreds of thousands of birthright citizens who wouldn't have citizenship in the United States if we changed the rule, who've been making tremendous contributions to our society. And I'll just mention a couple of birthright citizens whom you are fairly famous. You might have heard of them. Senator Pete Dominici, birthright citizen. His mother was an illegal Italian immigrant. Bobby Jinder, the Republican governor of Louisiana, is a birthright citizen. When he was born, his mother was here on a student visa. Bill Richardson, who was formerly running for president, is a birthright citizen, although he probably would have been a citizen by blood if he had been born outside the United States, but he has admitted in numerous speeches that his parents were really worried about making sure that he was born in the United States, so they put his pregnant mother on a train and sent her to California to make sure that he was born inside the United States. I'll just mention those few famous people because I think you've heard of them, but since I'm in the U.S. military, I am quite well aware that hundreds of thousands of people in the U.S. military today are birthright citizens. And they're birthright citizens of parents who are not authorized to be in the United States today, and yet they've chosen to serve their country of birth by putting their lives on the line for the rest of you. Opponents of birthright citizenship also assume, and again, this is without any data, that if we get rid of birthright citizenship, it'll stop illegal immigration somehow. And I think there probably are some people who would be deterred from coming to the United States if their children could not be citizens when they were born here. But I think more than likely what we'll end up with is actually more illegal immigration if we eliminate the rule, because we know from experiences in other countries that elimination of a rule and limiting the rule to just jus sanguinis does not stop illegal immigration. It just creates an underclass, the underclass of exploitable denizens that I believe you referred to earlier, Alex. Right now, their estimates are that the number of U.S.-born children of illegal immigrants is about 3 million, but nobody really has any good idea how many there actually are. So we need some facts before we actually decided to change the policy. Some people say there's about 200,000 to 400,000 born each year in American hospitals, but since hospitals don't track your immigration status of your parents, and they don't do the complex analysis right now to figure out whether you're really a citizen or not, it's hard to tell. Hospitals do report the birthplace of the parents often, but that doesn't tell you whether the parents are citizens of the United States or not. And some bad analyses have come out as a result of people assuming that anybody born in a foreign country must be illegal. So opponents of birthright citizenship, or the people who want to change the law, seem to assume without facts that if we change the law, suddenly things will be better in America. But I can predict that a lot of things will happen if we do change the rule, and I don't think these factors have been part of the debate up until now. First, in America, we'll have lots and lots of people who will be born with no citizenship. People will be stateless. And to just mention one particular group, under pending congressional legislation that a lot of people have signed on to, the language of the legislation says that even children of refugees and asylees who've been admitted permanently to the United States to live here forever, their children will not be American citizens. So most of these folks have fled from conflict-ridden countries, and they wouldn't have any status because the country that sent them to the United States or that they fled from wouldn't grant them citizenship anyway. So we'll have a group of people who won't have any citizenship at all. And then another argument is simply what I mentioned before. Let's do the cost-benefit analysis. Does it make sense to make 300 million Americans go through this process, this lengthy, complicated, convoluted process of having their citizenship adjudicated just to stop a little bit of illegal immigration, relatively little? Wouldn't it make more sense to use the money that we'd spend doing all this to maybe enforce immigration laws or perhaps reform them? And then another argument is this is simply not American. We've had this concept of birthright citizenship for forever, since the dawn of the Republic. It's a concept that is enshrined in our Constitution and that people have fought and died for, essentially, in the Civil War. And I can talk more about that in Q&A if you're interested. But what we're really talking about here is punishing children for something that their parents did, also a concept that many people would say is un-American. There's also a legal argument. I mentioned earlier that folks are saying, well, if you're an illegal or unauthorized immigrant, you're not subject to the jurisdiction, therefore your children are not citizens of the United States. And I find that argument really interesting because I think if people succeed in making that argument in Congress, then these folks would also be arguing that they're not subject to our immigration laws or our criminal laws or any of our other laws, because if they're not subject to our jurisdiction, well, not subject to the legal power of the United States. And then lastly, we'd just be contributing to the current global population of stateless people, which is not something that's in our national interest from a human rights perspective. So in sum, I think in the debate about birthright citizenship, people have neglected the policy aspects of it. They talk theoretically, they talk at the philosophical level about why it's a good rule or a bad rule. But the policy arguments against it, given the current environment, the current way our country is set up, current documentation rules, the policy arguments for repealing birthright citizenship are pretty weak. Even if you buy the argument that you can reinterpret the 14th Amendment to mean something it hasn't meant since it was enacted, it's not clear to me why you would want to do that, what benefit that would bring. And that brings me to a famous Texas saying that, since we were talking about Texas earlier today, I can invoke Texas sayings. There's a famous Texas saying, don't squat with your spurs on. And I think that changing the rules for birthright citizenship illustrates what they were talking about down there in Texas. Thank you.
So questions, comments? We have only 5-10 minutes here, but yeah, up there.
Hi, thank you. I'm Priscilla with the National Asian Pacific American Women's Forum. And my question is, I was wondering if the speakers could talk a little bit about the impact of a gender analysis on this, because I think the burden of birthright citizenship really falls on, the woman, the immigrant women who are bearing these so-called anchor children. So I'm wondering if you could speak a little bit about some of the policy implications about that.
Well, it's interesting, but in the area of derivative citizenship, the Supreme Court of the United States says it's okay, they've said it's okay to discriminate between men and women. Under the equal protection analysis, the court has said that women have a closer relationship to children through the birth process than men do. So it's easier for a child to derive U.S. citizenship through birth to a woman who's an American citizen than through a man. The people in the military find this interesting because apparently one of the reasons the court ruled the way it did was they were worried about the prospect of large numbers of American men being deployed overseas in the U.S. military and what they were doing in their free time. And that this would create, if they had the same rule for men as for women, that there would be a flood of American citizens instantly popping up overseas who had no ties whatsoever to America. But that it was more likely that if a woman gave birth, woman soldier, I guess, overseas gave birth to a child, that she would have that 9 months of relationship with the baby that should entitle the child to U.S. citizenship. So under current rules, men and women are discriminated against in derivative U.S. citizenship. And I know that doesn't quite answer your question because I think you were talking about anchor babies. But anchor babies can pass on their citizenship, or theoretically can, to either their father or their mother. There isn't discrimination there. In the law right now. There is discrimination for derivative citizenship, but not for birthright citizenship. Alex? No?
Other questions, comments?
Can I ask Margaret a question?
Yeah.
Sure.
Okay.
Do I have to answer it? Are we in
No,
court?
no, you don't. You can take the fifth. Lots of the birthright citizenship rule that the United States has is broader than almost every other country in the world.
Yep.
So the vast majority of countries live with other regimes that are jus sanguinis regimes. So imagine you're up on the Hill testifying this afternoon, and someone says to you, "So what about France, Germany, England, all these other countries that don't have the breadth of the rule? They seem to have systems that work." How do you respond, given your policy analysis? Those systems seem to function as citizenship functions with systems with different rules.
They do. Luckily, I'm not going to be testifying about this afternoon,
Oh, okay.
as far as I know. No slipping notes, okay? But the reason their systems, quote, function is because of the history of those systems within those countries, which is a tremendously different history than the history that we
Well,
have.
actually, Britain switched from full birthright citizenship to the jus sanguinis system a number of years ago.
Yeah, they did. And they had significant issues with that when they did it. It caused tremendous administrative issues. But they also had in place a much easier system administratively than we would ever have. The United States, in addition to being unique with having birthright citizenship, is unique that we register births all over the place, over 8,000 different locations in the United States. We have, midwife births. We have all kinds of, we do need, if we're going to do this, we're going to have to create some kind of national birth registry, which we don't have. And perhaps that's something that we need to do. We're now creating a national driver's license database, and we're basically going to a national ID card through the driver's license system. So maybe someday we'll have a national birth registry. But that's something that we need to bring out in the debate. We need to talk about doing that and what the administrative costs of doing that are, which are tremendous. I've noticed this because in the military we have a problem with this too. I got a call from somebody in Georgia who was upset. He's a Vietnam War veteran who happened to be born in Canada in a U.S. military hospital in Halifax that no longer exists. And the only time he ever left the United States after his parents brought him back into Georgia when he was a small child, he only left the United States to go fight in Vietnam. And he didn't need a passport to do that. Okay. So he went off to Vietnam and he fought in Vietnam and he came back to Georgia, and he's been living in Georgia ever since. And he was very offended by the fact that the Georgia Department of Motor Vehicles won't give him a driver's license anymore because they said that he's not American because he was born in a U.S. military hospital in Halifax, Canada. And apparently the Georgia DMV was willing to give him a driver's license if he could come up with his birth certificate from the Canadian hospital or the U.S. military hospital. But he had a Canadian birth certificate, not a birth certificate from a military hospital. So he was calling me so I could get him his birth certificate from this defunct American military hospital where he gave birth. His mother gave birth to him in 1950, and of course nobody knows where the hospital records are. No, I don't have his birth certificate. So I was trying to help him, and I said, "Well, you can apply for a U.S. passport." He got very upset. He said he doesn't ever want to leave the United States. He's got no need for a passport. The only time he ever left was to go fight in Vietnam. You can imagine the conversation. And he couldn't see why he had to get a U.S. passport in order to get a driver's license renewed in Georgia. So we kind of left it at that. But I think this illustrates that, the British, I think, are known for their ability to do administration, and we're not.
I'm not sure that's what people in India would say, but let me just give you one other policy reason that I'll attribute to David Martin. Said a long time ago that the great thing about a birthright citizenship rule is that there are no second-generation immigrants in the United States.
Right.
And so while lots of other countries deal with these continuing, even assuming we knew where everybody was, we could identify other countries that have basically jus sanguinis systems have continuing generations of immigrants. And in much of the debate about undocumented migrants, supporters of regularization don't have to worry about the number being huger than it otherwise might be, because we don't count the children of undocumented immigrants as undocumented, right? They're U.S. citizens if they're born here. So it's I think it's a very strong reason for maintaining birthright citizenship that we only draw that line for one generation, and then we're all in it together. So another argument.
Yeah, I mean, the demographics are interesting. I work on Army recruiting issues occasionally. I get questions about, can I join the Army, that sort of thing. And without birthright citizens, we would not be making our recruiting goals at all. You know, we have an all-volunteer force. We couldn't maintain the all-volunteer force, so we'd have to draft everybody. All of you in the audience who are under 26, you're fair game? No. Now, interestingly, this would solve illegal immigration to some extent, because one of the interesting benefits that you have if you're an undocumented immigrant is you are eligible for the draft. If you're an undocumented male between 18 and 26, there are any of you in the audience, you are required to sign up for the draft. So if we do have a draft, we can draft you, and then you can become a citizen. Because if you serve in the military honorably in wartime, regardless of your citizenship status, you can become an American citizen with 1 day of active duty honorable service. So that would probably, you know, if we get rid of the birthright citizens, then we could institute a draft, then draft them all and make them citizens. Got it? Okay.
We should probably end on that note, maybe. But I wanted to thank Alex and Margaret again, and please do come back by 1:15, because our next speaker will start then. So thank you.